Hello everyone, this is the video of Legal Studies class 12 unit 1st, that is Judiciary, and in this video I will be discussing about the High Courts of India. So there are different High Courts in every state almost. However, some of the High Courts have jurisdiction more than one state. For example, Punjab and Haryana High Court. It has two states jurisdiction as well as one union territory jurisdiction, that is of Chandigarh. So total it has three: Punjab, Haryana and Chandigarh. So there are some high courts which have the jurisdiction more than one state. Otherwise, most of the high courts have only one state jurisdiction. So we will check everything here. So let's start with the constitution, because its existence is derived from the constitution itself. So article 214 says that there shall be a high court for each state. As I have said in my previous video as well, that judiciary's existence is taken from the constitution itself. So that provision of the constitution that defining the existence of judiciary, basically the high court that we are discussing in this video, is article 214. Next one is article 215, that states every high court shall be a court of record and shall have all the powers of such a court, including the power to punish for contempt of itself. So it is again same as we have studied in reference to the Supreme Court, because article 129 we have studied that, saying the same provision. So I believe you must understood here, because the provision is same, that was in context of Supreme Court and it was in context of High Court. Next one is article 216, states that every high court shall consist of a chief justice and such other judges as the president may from time to time deem it necessary to appoint. So this article is simply saying that the number of judges in a high court will depend. As the president thinks fit, he can increase the number of judges in respective high court. So it's not like that every high court has the same number of judges, not at all. Every high court has different number of judges. For the example, Allahabad High Court has the most number of judges in comparison to other high courts. So every high court has its own number of judges, and in the last of this video I have given the table in which you can just check out which high court has what number of judges. The last provision, that basically including all those provisions of the constitution that talk about the high court, that is starting from 214 to 231. Now let's check out what are the jurisdiction of high courts. As we have seen that Supreme Court has different jurisdictions. Similarly, high courts have different jurisdictions, but now I believe that you understand what is meaning of jurisdiction. The first jurisdiction of high court is original jurisdiction. The second one is appellate jurisdiction, and the third one is administrative jurisdiction. Now in comparison to the Supreme Court, where you found one more jurisdiction, that is advisory jurisdiction, but that advisory jurisdiction is not here. So we have only three jurisdictions here. Original jurisdiction, that is under article 226, that is talking about the issuance of writ and here the cases of public interest. So under article 226, high courts have the writ jurisdiction. Apart from that, we have discussed the different terminologies, that is PIL, public interest litigation. So high court have jurisdiction regarding the public interest litigation under this article only, 226. Judicial activism, we have also studied that. So again high court has judicial activism kind of jurisdiction under article 226 only. So do not forget this article. Now let's check out the next jurisdiction, that is appellate jurisdiction. As we have seen that the case primary need to be filed in the lowermost court. However, it depends upon the kind of case it is, but in the High Court or in the Supreme Court, largely case goes through appeal. So it has the appellate jurisdiction. And there are two types of appellate jurisdiction. That is, the first one appeals in civil matters and the second one appeals in criminal matters. The last one is administrative jurisdiction of high courts. Here we have different types of administrative jurisdiction that high courts have. So let's check out one by one. The first one is High Court makes and issues rules regarding the working of the subordinate courts. Second one is High Court superintends and commands all the subordinate courts and tribunals in the state. The third one is High Court can ask for details of proceedings from any of the subordinate court. What does it mean? That if any case is going on in the subordinate court, say in the district court, then High Court has the power to ask the detail about those cases. Next one is High Court can inquire into the records or other connected documents of any subordinate court. So it is the authority basically to check every sort of document and all the cases that we have discussed in the previous point as well. Next one is High Court has the power to transfer any case from one court to another and can also transfer the case to itself and decide the same. So we have seen this point as well in reference to the Supreme Court. So High Court can transfer the cases from one district court to another district court, or it can transfer from district court to itself and decide the things. So it has the authoritative power. And the last point is High Court can appoint its administrative staff and determine their salaries and allowances and conditions of services. So these are the certain administrative duties, powers of the high courts that they perform. The next one is the powers of the High Court. Though just now we have seen under the heading of administrative jurisdiction what are the duties and powers, so it is exclusively dealing with the powers of the High Court. So let's check it out. The first one is govern the jurisdiction of lower courts, issue direction, orders or writs. Third one is supervise all the subordinate courts and tribunals falling in its jurisdiction. Fourth one, that is withdraw pending cases from a subordinate court and dispose of all such cases itself. Fifth one, review and revise the judgments of subordinate courts. This is the new one that we haven't discussed in my earlier point while discussing the administrative duty. So this is the new one, otherwise more or less the same points. And the last one, that is transfer of certain cases. We have also discussed this. So it's something like powers and administrative duties, something like overlapping somewhere. Now the last heading of this video is number of high courts in India. At present, total number of high courts in India is 25. Established on July 2nd, 1862, Calcutta High Court is the oldest, and set up on January 1, 2019, Andhra Pradesh High Court is the newest High Court. Besides, following table illustrates the names with establishment dates of all the 25 High Courts of India, so you can check it out in detail.